Testing, testing. Testing, testing.
Can you guys hear me?
Yep, thank you.
You can? Great.
Yes.
All right, welcome to the Public Service Commission's administrative meeting for July 31st, 2024. First item is approve the minutes from our meeting of July 24th, 2024. Commissioner Sussman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Morning, Mr. Chair. There are 4 items on today's consent agenda. Item 1 is a notification of a change in the Prince George's County energy tax from Washington Gas Light Company. Item 2 is a revised Montgomery County fuel energy tax surcharge tariff from Washington Gas Light Company. Item number 3 and 4 are notifications of changes in the Montgomery County fuel energy tax from Baltimore Gas and Electric Company and the Potomac Edison Company.
Okay, regarding items 1, 2, 3, and 4, I move that we note the filing with an effective date of July 1, 2024, and grant a waiver of the 30-day notice period required under the Public Utilities Article 4-203A. Commissioner Sussman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye. And regarding... Oh, no, go ahead.
Item number 5 is a request from the Potomac Edison Company for a CPCN waiver.
Good morning, Mr. Chair and Commissioners. First of all, on behalf of staff, on May 24, 2024, Potomac Edison filed a request with the Commission for a waiver of the CPCN requirement as set forth in the PUA Section 7-207B4I to install 2 230 kV line loops from the existing Duke Lime Cube 230 kV lines into a switching station and extend the lines into the Bikeside substation located in the Frederick County, Maryland. In PUA Section 7-207, an electric company is required to obtain a CPCN prior to commencing construction of an overhead line that is designed to carry a voltage in excess of 69 kV. The PUA further states that the Commission shall waive the CPCN requirement should it find that the construction does not require the company to obtain the new property or right of way, or require larger or higher structure to accommodate increased voltage or larger conductors. This project will allow Potomac Edison to provide electric service to Rowan Green Data LLC's proposed data center complex at the Quantum Loophole Data Center campus in Frederick County, and it will be served directly from the substation. According to the company, the project includes installing 2 230 kV transmission line loops and a total of 8 new structures. Potomac Edison anticipates that the construction will begin in September 2024, and no customer will be impacted during construction. Staff concludes that the statutory requirement under PUA Section 7-207B4I for obtaining a waiver of the CPCN requirement is satisfied. Staff recommends that the Commission grant the company request for a waiver of a CPCN requirement under the PUA Section 7-207B4I to install 2 230 kV line loops from the existing Duke's Limecube transmission lines into a switching substation and extend the line into the Bikeside substation. Thank you.
Any questions for staff? Commissioner Richard.
Yes, thank you, Mr. Chair, and thank you for that presentation. Just a question about the recommendation. You are recommending that we do this under the waiver, the
Correct.
required waiver. Would staff have any, concern if we were to do this for good cause under the good cause section of this, the Public Utility Act? Are you indifferent, or is there a specific reason you'd prefer to go one way, or is it, objectionable to staff to do under good cause?
Sure. Yes, Commissioner Michael Dean on behalf of staff. It was requested under that section, but staff has no objection to using the general waiver.
Okay. And would some of the issues be, I guess, it was talked about for reliability purposes to advance this economic project? Would those be reasonable for, justifying I guess, the good cause section?
Yes, Your Honor.
Those would be sufficient. Great. Thank you. Those are all the questions I have.
Mr. Schlesman.
In terms of the new lines that are proposed to be built, can you speak to the impact on reliability? Is it will the new lines enhance reliability? Have any impact on reliability? Have you looked at the issues around reliability?
Yes, the new line loop is supposed to improve the reliability and also address PJM's concern about, any violation if there's a data center connected to the substation. So yes, the project will improve reliability.
Okay, so reliability to the extent if the line weren't built, then there could be reliability when they connect the data center. If we take the data center off the table, in terms of other customers within the PJM footprint in the P system, would this line enhance reliability for those customers as well?
If there are no data center, there will be the line loop. There's no project for this project.
Okay, so this assumes data center, if a data center interconnected to the grid, and the line would enhance reliability for other customers within the PJM footprint.
To my understanding, the line does not serve any customer right now, but with this line loop, it will improve the overall reliability.
That's my question. Okay, thank you.
Mr. Barve, any questions?
No questions. Thank you, Mr. Chairman.
Okay.
Good morning, Chair Hoover and Commissioners. Joey Chen on behalf of Potomac Edison, and it's good to see you all again. Here with me today is Travis Turner, who's one of our engineers, and I first would like to thank staff for their excellent presentation and analysis. Excuse me. I did want to, if I may, just clarify a little bit more to your questions, Commissioner Suchman and Commissioner Richards. So this project, if you think of it in two parts here, one is to connect the customer. So customer is the data center developer, and they have a particular need to run lines into their substation. And now the second piece of it is more of a PJM lens. And so when PJM looked at how best to do this, they identified necessary upgrades to the actual project design that involved looping not one but two 230 kV lines into the switching station. And to answer your question, Commissioner Suchman, PJM did that for reliability, specifically for reliability reasons, understanding that not only to take into consideration Rowan's anticipated load, but the other load to be served, currently being served, and to be served in that area, altogether about 1,355 megawatts. And so the design, this particular design as we proposed, that is looping two lines, 230 kV lines into this particular substation, is actually intended to meet, PJM's planning criteria as well as the company's planning criteria to ensure reliability, because we anticipate that we do not want to see a situation, in fact cannot, where we have no more than 300 megawatts of load that would be interrupted by any particular criteria. So So that is the reason for the benefit of the particular design as we've proposed it. So I hope that does answer your question, Commissioner Suchman. Commissioner Richard, I'm sorry, if you could repeat your question.
Oh, I was just interested to get from staff, what their thoughts are about doing this under the provision that we can do this for good cause, instead of going the route of the required waiver.
Right. So staff is correct that the company proposed this under the 7-207 B4 Romanet 1 provision for a mandatory waiver because the company believes that the project does fit the elements for granting the waiver in that case. I mean, we are not looking to and would not be requiring any new real property issues, no need for eminent domain, for example, and the structures that we are installing in this particular instance, the 8 structures, their average heights do not exceed the average height of the existing structures. However, even if the individual structures could be, taller here and there, I mean, we are not looking to, increase the conductor size or they're not necessary to accommodate a larger voltage. So, looking strictly, at the statutory test, if you will, the company believes that it does meet the requirements under, 7207B4 Romanet 1. But if you were to ask the question in terms of staff's, comfort level in terms of proceeding under a good cause waiver, I mean, the company would also agree with staff that good cause does exist here because of some of the points that we'd already discussed. Not only is it necessary to connect a customer for the purpose of their substation in their project, but it also does go to that is the specific project design. It goes to enhance and improve the reliability of, according to what PJM has identified for the area.
May I ask a few more questions? Or
Sure. Yeah.
yeah, good. Well, thank you for that. As far as just some of the another question, I want to get back to just in a moment. But the reason for this, of course, is there's a brand new customer that needs to be served. If this customer is this customer locked in, I guess, because if the customer doesn't materialize, there are some expenses that would be socialized to both the transmission and distribution system. So, what are there protections for the general customers if this one customer doesn't appear?
Well, we don't have any reason to believe that the customer isn't
Okay.
committed. I believe the customer developer is committed, and I believe Travis can clarify as he needs to, but I do believe that customer is committed. So there isn't a question of the customer not coming onto the system. And I do think that if just in general, as far as when the company works with a customer, there are intake processes, and there's where the customer is puts forward its commitment by way of financial deposits and things like that, where it does behoove. I'm speaking in the general terms
Yeah,
here.
I just want to get this on the record.
Right. It behooves them to stick with the project, and there are some. Depending on the circumstances, we do have agreements, just to be clear. We do have agreements with the customer, and there are depending on the circumstance, sometimes we have agreements in place where, the customer could potentially absorb costs if they decide that they're going to abandon their project.
Okay, so beyond just that, it looks like they have a commitment for a little over $2 million. You say that it may go beyond that under the agreement the company has with the potential customer right now?
No, the customer, the customer's level of contribution is, has been agreed on to the customer. So that much is already determined.
Okay, so
and
it's just
set.
a little over $2 million of the $33 million the customer has agreed to, under any circumstance, contribute to this project.
The customers agreed to contribute their portion to this project. So that is the 2.17 million.
Okay. And I'm asking the right person these questions, of course, since you've had some experience with the Public Utility Commission. why are we going the route of a waiver? The statute, I mean, the CPCN process is meant to be an expedited process in itself. Is there a particular reason why it's important to the company to go to waive this expedited CPCN process?
So the CPCN process under 7207 is a very extensive and robust review process.
Right.
I think it wouldn't come as a surprise if the historically the review process from start to finish, once an application gets filed with the commission to an order that's issued, either from the Public Utility Law Judge Division that's then becomes a final order, or from the commission itself, can range anywhere from 12 months to 18 months or even longer. And then there's, of course, a potential appeal window to that. So, I mean, it is more robust, but the downside to submitting every project to a CPCN process is, of course, time and resources. So usually when the company plans with the customer of a particular project, I mean, of course, a lot of different considerations go into a decision as to, the scoping of the project and then the approval process, the regulatory process, the best approval regulatory process to apply for. For the CPCN waivers, that is a statutory provision that the General Assembly has created that allows the utility companies to come in and apply, let's say, for a smaller scope projects that don't necessarily require as much of a robust review through the PSC. But then, because if a project is available and meets the criteria for the waiver, then that enters its own benefits, right? To not only the customer, to the company, to the commission itself, because the commission has its own resources to consider.
Okay. And you could agree or disagree, but do you find this project to be somewhat different than, I guess, the classic reason for the automatic waiver, and that is to reconstruct an existing transmission line? In this case, it appears that it's not just a transmission line, but it's for a new purpose. It has additional towers. It will actually be partially in the company right away, but also go into other property. So it seems like it's slightly stretching, I guess, the purpose of the automatic waiver to go this route. However, there seems to be good reasons to go the good cause route. Do you have any comment on that? I mean, would be setting any kind of a precedent if we were to go this the shall give the waiver, as opposed to going with the other option, and that is a good cause waiver?
I think that's an excellent question, Commissioner, and maybe I can indulge. I mean, if I had another hour,
I don't mean to do that. I just wanted to get
No.
just a few things on the.
Yeah, no, I jest, but I'm not in a position to try to opine on the legislative history to enough to say whether or not I agree that the intent of that particular provision of the statute was only meant for rebuilds. So I can't comment on that. But I will say that that what we're asking for here in this project is not necessarily new precedent, because the commission has granted the mandatory waivers or waivers under the mandatory provision of the statute before, for not only Potomac Edison but for other companies. And now, just to give you a few examples for Potomac Edison, commission and similar, these supplemental projects, tap lines to the new Garfield substation, the commission granted that request in April of 2018, granted a similar loop, not a similar, but another loop line project to the proposed West Jefferson substation, and this was granted by the commission in April of 2019. So there are other examples that I can provide where they're not strictly limited they're not identified as rebuilds, but they're work that the company put forward to the commission under the mandatory waiver provision, and the commission approved. So in other words, we're not proposing necessarily anything new by way of a new approach or a new project to be qualified under the mandatory CPC and waiver. This is just a project that the company felt that it met the test under 7207B for Romanet 1.
Okay, well, thank you for that. I don't want to prolong this, Mr. Chair, any longer, but, I would like to suggest we be careful that, we'll have all these maybe similar situations. I think we should be very cautious when we use the automatic waiver or the required waiver, especially when we have the option of using the good cause waiver. So I want to support the company, but I'd like to suggest to you that we do this under PUA 7-207B3 Romanet 2 rather than the Romanet 1, which I believe, if I'm correct, maybe staff can correct me, that would be the good cause route to go rather than going the required waiver. Is that correct? I think we can do this. We can do this pretty
Answer your question.
We can do this pretty simply. And I'm taking that from the Buck sheet.
Yes, Your Honor, that would be correct.
That would be correct. Okay, thank you. No other questions. Thank you, Mr. Chair.
Commissioner Sussman.
So talk to me about the quantum project. So this is a data center project, correct?
The Rowan project is one of the projects that will go into the Quantum Loophole campus. That's correct.
Okay. If this project weren't being built, would you be here today asking for a waiver of the CPCN requirement? Or would you be building out this line at all?
I think the company is looking to solve the issue, address the issues that are coming from the data center projects, and I mean,
But so that is
whether or
that's the
not
driver for
it's
this.
that is now or down the road when we have a customer like Rowan coming through for a similar request. I mean, we would be here before the commission. Yes, I think it's fair to say that the initial driver that put this in front of PJM was the working with the customer to connect this particular customer.
Okay. Is there any other driver? If there were no data center project, would there be any need for the project that you are proposing today?
So thanks for that question, Commissioner. I'm going to ask Travis Turner to share his thoughts on this.
Sure.
Good morning. Travis Turner with First Energy, employed as an engineer. Commissioner, to answer your question, yes, the main driver for the project right now is the customer, Rowan. Whether we need to rebuild that line, we don't know. PJM may come back in the future and say we need to rebuild that line for reliability or for load issues,
But not today.
but not today.
Okay. So if there were no project, no data center project, you would not need to build out this line.
That's correct.
Okay. And the line is $33 million to do the project. Is that correct?
Yes.
Okay. And how much of the 33 million is the data center covering?
So The majority of the cost, let's say it's I'm going to say of the 33 million, you have about 27 million that's not related to the transmission line work.
Tell me what the 27 million is related to.
Okay, so the 27 million will go to the switching station, the proposed new switching station we will run the loop lines into that switching station.
For this new data center.
That's correct. Yes,
Okay.
that's correct.
And the data center is going to pay for that 27 million?
No, the 27 million are considered network costs because they provide network benefits, and so those the company will seek to recover through its transmission rates.
Okay. So data centers coming in, asking for upgrades to be able to interconnect, and your customers are paying for that.
Well, customers will be paying a portion of that because there's the regional costs, the zonal cost allocation. It'll be subject to that, but that in a nutshell, that is true.
Okay. So can you explain to me why the costs? These are all sort of necessary upgrades to accommodate a data center. Why isn't the cost being borne by the data center?
Because the data center is not the only customer that will benefit from the upgrades to the switching station into the system in general. So, I mean,
But customers don't need it right now. They don't need the upgrade to the switching yard. They don't need upgrades to the wires. The upgrades are only coming because of this new data center. See, and this is Mr. Chair, this is the concern I have in taking a waiver process that's intended for one purpose, and then putting it onto another purpose, which is, you're going to get more data centers coming in, and more data centers are going to put more burdens on the system, and then you're going to come to us for a waiver, and we're going to sort of rush all this stuff through, and the data center may come or not come, but the one thing I'm seeing is an increase in the cost for the network that's going to be borne by the ratepayer. I don't really understand why this can't just go through a regular CPCN process. I mean, what's going to happen if you went through a regular CPCN process, the data center is going to want to be there or not be there? Or is the concern that the data center is going to go away?
The data center is not going. Well, this particular customer's data center, we have no reason to believe that this customer's data center is going to go away. I mean,
and you don't have a reliability issue right now for current customers, which I can understand would be a reason why you'd want to pursue a waiver. The customers are not experiencing a reliability issue. I guess they would experience a reliability issue once you interconnect the data center without the upgrades. But I'm not really understanding why this can't just go through a regular CPCN process. I'm concerned that this is going to be the exception that's going to swallow up the rule, so that we no longer have a CPCN process. We just have a waiver process.
So I would be remiss if I didn't bring us back to the statute. So there is this. The General Assembly did speak specifically and allows for, in a limited scope, a project that meets the test for mandatory waiver. And historically that I have seen, maybe not necessarily on the side of the company, but I've seen the commission granting these type of requests because there's really no discretion on the commission side. That the language of the statute is that the commission shall waive, and it's the governing test that would apply. There are going to be projects that are going to be related to data centers and that are going to come through Potomac Edison, where Potomac Edison will need to be submitting a full siting application. We don't believe that the full siting process is necessary for this particular project because the project meets meets the requirements under 7207B4 little I. But there are going to be benefits. I mean, we from a timing standpoint, I mean, I cannot, look you in the eye and tell you that there's an immediate reliability need right now. What I can say is that PJM looked at the bigger picture of this particular customer's data center, took into consideration the total forecasted load addition for that area, and believe that the project as we've designed it here is needed in order to protect and ensure that there's going to be the reliability sufficient to support the anticipated load that's going to be coming onto that area. Is that load there now? No, it's not. But there are other customer loads, and the network flows through that are connected to the 230 kV system. The 230 kV system that this upgrade will still inure benefits to those other substations that are connected.
Yeah, I don't question that there's going to be reliability benefits. I'm not understanding why this cannot go through under a regular CPCN process. I worry that this is going to become this slippery slope where we're just going to have one request for a waiver after another.
So I'm sorry, Commissioner, I was just asking my colleague
That's
here
fine.
for a little better understanding in terms of a timetable. So, the CPCN process, as we've already discussed this morning, it's not an instant process. It takes a long time compared to a waiver request because of how thorough and robust the review is. The company, when Potomac Edison, when working with the company on projects like these, also have to take into consideration the customer's timetable for when they need to construct a project. And so I will say that that the particular customer here, that a full CPCN review is not their timing needs for their project. It's the CPCN process.
See, and that's
doesn't work, but-
exactly what I'm concerned about. Is that I'm concerned that so much of this is being driven by this particular customer that wants to get connected as soon as possible, and they're getting connected to a large transmission system, and they take it as it is. And I worry that this is just the beginning of a process. It could be data centers, it could be any number of customers that want to get connected, and it's going to be the exception that swallows up the rule. And so we will lose the value and importance. The CPCN process is a critical part of what we do, not just to protect the grid, but also to protect ratepayers. And I think the fact that ratepayers are covering the lion's share of a project that is going to benefit a single customer, I think is part of my concern.
Well, so I don't need to go further into it. Just only to say that I would respectfully disagree that the project is going to solely benefit this particular customer. But again, I think we have to take it back to where we are with the statute and what the General Assembly has already provided by way of, there is the established CPCN review process, but, the General Assembly did also recognize that there needed to be, some sort of alternatives to the full review. And so it created the mandatory waiver, the good cause waiver, and made those available. So we have gotten projects. Maybe they're not all data center projects, but they are other line loop projects or substation related transmission line structure work that are not necessarily rebuilds, but the commission put them forward under the mandatory process and waiver process, and the commission has approved those. That's essentially what we're asking the commission to do here. I recognize the concern, and again, time will tell in terms of the benefits, the greater network benefits that do actually get realized through this project. But I would, just close by stating that right now, what we presented to the commission is a request to approve under the statutory route, mandatory waiver request route. Believe that this project does meet the requirements of the statute, and that the commission should grant or must grant the request.
Well, I'm going to turn it back over to the chair, but I have some great heartburn about approving the request for a waiver at this point.
Commissioner Barbie, any questions?
No, I think that Mr. Chen expressed what I would have asked a question about, specifically legislative intent, and would remind everyone that Maryland and the United States both are going through a process of reindustrialization, and that means electricity. So I think my question was answered.
Okay. All right, with that, I'm actually going to move that we grant the company's request for a waiver of the CPCN requirement under Public Utilities Article 7-207B3 to I. Commissioner Sussman.
Nay.
Commissioner Barbie.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Mr. Chair, item number 6 consists of revised tariff pages from the Easton Utilities Commission.
Good morning, Mr. Chair and Commissioners. Eric Delgado on behalf of staff. With me is Alden Monca from the Commission's Telecommunications, Gas, and Water Division. On June 27th, 2024, Easton filed proposed revisions to its gas and electric service tariffs to comply with Commission Order 91207 in case number 9719. Per the settlement agreement delineated in the proposed order of the Pool J, which became the Commission's final order on June 22nd, 2024, Easton has been authorized to collect $470,000 in incremental revenue for gas services and $4,291,059 in incremental revenue for electric services. The incremental revenue increase for electric service is separated into 2 phases, with the first phase beginning for bills rendered on or after July 1st, 2024, and the second phase taking effect for bills rendered on or after October 1st, 2024. Residential customers with a monthly usage of 1,000 kilowatt hours can expect a $13.67 increase during the first phase and an additional $7.20 increase during the second phase, for a combined $20.87 increase in base rates for electric service. The full increase for gas service is implemented in one phase for bills rendered on or after July 1st, 2024. Residential customers with average gas usage can expect a monthly bill increase of $8.68 for gas services, representing a 7.67% increase. Staff recommends the Commission accept Easton's proposed gas and electric service tariffs for filing with an effective date of July 1st, 2024. And please note that the recommendation in staff's written comments, which indicates an effective date of July 31st, 2024, is a typo. Per Commission order for case number 9719, rates take effect on July 1st, 2024. And thank you. I'm available for any questions.
Any questions for staff? Alrighty. With that, I move we accept the tariff revisions for filing with an effective date of July 1, 2024. Commissioner Sussman.
Aye.
Commissioner Barbie.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Item number 7 consists of revised tariff pages from Baltimore Gas and Electric Company.
Good morning, Mr. Chair and Commissioners. Evan Thomas on behalf of staff. On June 28th, 2024, Baltimore Gas and Electric Company filed revised tariff pages to remove Gas Rider 16, which is its stride rider, from its gas service tariff. As noted in staff comments, the filing follows the Commission's letter order from May 1st, 2024, which was in regard to BGE's final Stride 2 true-up, which was case number 9468. The letter order required BGE to file revised tariff pages by June 30th to remove Gas Rider 16. We have reviewed the revised tariff pages, and Rider 16 has been removed and all reference to it. And so staff recommends that the Commission accept the revised tariff pages for filing with an effective date of August 1st, 2024. Thank you, and available for any questions.
Good morning, Commissioners. Beverly Sukra on behalf of BGE. Hopefully this is one of the simpler filings that come across your desk. No other comments, though. Yep, it's out. It's done.
Okay. Any questions for staff or the company? All right. I move we accept the tariff provisions for filing with an effective date of August 1, 2024. Commissioner Sushman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
All right. I believe we can call the next two together. If not, please staff advise me. But items number 8 and 9 are revisions to green rider rates for Delmarva Power and Light Company and Potomac Electric Company.
Good morning, Chair and Commissioners. The items can be called together. Paige Shaw on behalf of staff. On July 1, 2024, DPL and PEPCO submitted proposed tariff revisions to their green rider rates to reflect up-to-date renewable energy credit market prices. The rider provides 100% renewable energy, and it is voluntary for the plug-in vehicle and residential plug-in vehicle rate schedules and mandatory for the public charging plug-in vehicle rate schedule. The proposed rate is 0.02289 cents per kilowatt hour, which is a 7.3% increase over the existing rate of 0.02133 cents per kilowatt hour. Staff recommends the Commission accept the tariff pages for filing with an effective date of August 1, 2024. And with that, staff is available for any questions.
Any questions for staff? I guess the only question I got is, I take it there's no difference other than the company name between item 8 and item 9, right?
Correct. The
Okay.
rate is the same for both companies.
Sure. And Ms. Beckham?
Good morning, Chairman and Commissioners. Taylor Beckham here on behalf of Potomac Electric Power Company and Delmarva Power and Light Company. We appreciate staff's review and have no further comments and are available for questions. Thank you.
Any questions for Delmarva or Pepco? All right. So I think I will do them separately, though. Regarding item 8, I move we accept the tariff revisions for filing with an effective date of August 1, 2024. Commissioner Sushman.
Aye.
Commissioner Barbe.
Can I make
Aye. Commissioner.
on behalf of Office of People's Counsel? Sorry to interrupt.
Actually, you're going to have to stand at the mic because I can't hear you.
Sorry to interrupt. I was just looking to make a statement on behalf of Office of People's Counsel.
Oh, I see.
Items
Okay.
8 and 9.
Actually, did they file anything in this? Well, actually, go ahead.
So, apologies again
Sure,
for
sure.
interrupting. Isaac Lindenbaum on behalf of Office of People's Counsel. OPC supports staff's recommendation to accept the company's tariff pages with one cautionary note. The Commission should not conclude at this time whether the green rider rate is or is not marketed to customers. The definition of marketing under SB 1 should be determined in the rulemaking proceeding that staff has requested to revise regulations to implement SB 1's provisions governing green product offerings. Thank you. I'm available for any questions.
Any questions for OPC? Yeah, go ahead.
And Ms. Beckham, are you okay with OPC's request or recommendation?
I understand that this rate is not marketed to customers, so
Okay, so there's no issue.
no,
Okay.
I wouldn't think so.
That-
All right.
staff's understanding?
Yes, Your Honor.
Okay.
This was originally approved under the standard offer service provisions, and standard offer service is not marketed.
Okay. Okay, good enough. So, item 8, I move we accept the tariff revisions for filing with an effective date of August 1, 2024. Commissioner Sushman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye. Item 9, I move we accept the tariff revisions for filing with an effective date of August 1, 2024. Commissioner Sushman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Okay, we will take items 10 and 13 together next. These are Empower-related revisions from Delmarva Power and Light Company and Potomac Electric Power Company.
Good morning, Chair and Commissioners. Paige Shaw again on behalf of staff. On July 1, 2024, DPL and PEPCO submitted proposed updates to their Empower Maryland surcharge for the remainder of 2024. On June 4, 2024, the Commission, in Order Number 91175, which adopted HB 864, directed the Empower Utilities to make a compliance filing modifying the Empower surcharge to reflect its average cost of outstanding debt with an effective date of July 1, 2024. Staff has reviewed the filings and notes that the proposed surcharges are calculated correctly. DPL's proposed residential surcharge is 0.008224 per kilowatt hour, which is a 3% decrease over the current rate of 0.008499 per kilowatt hour. PEPCO's proposed residential surcharge is 0.01156 per kilowatt hour, which is a 3% decrease over the current rate of 0.011342 per kilowatt hour. Staff recommends the Commission accept for filing the proposed surcharges with the effective date stated in the company's tariffs. And staff is available for any questions. Thank you.
Okay, any questions for staff? All right.
Good
Well, actually,
morning.
let me
You want to do
go to, yeah.
Good morning, Mr. Chair and Commissioners. Nicole Zeichner on behalf of the Maryland Office of People's Counsel. We had no concerns with how PEPCO and Delmarva calculated the revised tariff. Our only concern is that the tariff language itself should reflect the average cost of outstanding debt versus the prior language that referenced or rate of return. That would be just for purposes of customer transparency and clarity. So that would be our only recommendation regarding PEPCO and Delmarva, and I'm available for any questions. Thank you.
Okay, so let me turn to the company and then I'll come back to staff. So,
Good morning again, Chairman and Commissioners. Taylor Beckham on behalf of Delmarva Power and Light and Potomac Electric Power Company. The company, PHI, has no outright issue with OPC's suggested language, but just would note that there are additional tariff changes that will likely come out of the Commission's consideration of the upcoming cost recovery work group report. So for purposes of efficiency, it could all be edited at that time if the Commission decides to go ahead and just accept what we've filed already. So I just would make that statement. Thank you.
is it sort of staff's view on this? Or?
Yes, that's staff's view.
Okay. All right, well, given that, I think we're just going to go ahead and approve Delmarva and PEPCO's tariffs, and then we'll take this up when we do this work group on the other revisions. So with that, regarding item 10, I move we accept the tariff revisions for filing with an effective date of July 1, 2024. Commissioner Sushman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye. Regarding item 13, I move we accept the tariff revisions for filing with an effective date of July 1, 2024. Commissioner Sushman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Item number 11 consists of revisions to rates for Empower from Southern Maryland Electric Cooperative, Inc.
Good morning, Chair and Commissioners. Andrew Schlicht on the behalf of staff. Pursuant to House Bill 864 and Commission Order 91-175, SMECO filed proposed tariff revisions for their Maryland Empower program. As a result of changing the utility's return to its average cost of debt, SMECO proposes a near uniform 1% decline in its related surcharges. This decline will apply to its energy efficiency program related surcharges while leaving the demand response program surcharges unchanged. It is expected that the monthly bill impact for an average SMECO residential ratepayer will decline by roughly $0.12 or 12 cents. Staff recommends approval of the proposed tariff revisions, and staff is available for questions.
Any questions for staff?
Good morning, Chair Hoover, members of the Commission. Damon Krieger on behalf of Southern Maryland Electric Cooperative. Thanks to staff and to OPC for their comments, and to the extent you have any questions, I'm here to address them. Thank you.
I take it you didn't twist staff's arm to agree with this, right?
What's that? No twisting.
With that, I move we accept the tariff revisions regarding item 11, I move we accept the tariff revisions for filing with an effective date of July 1, 2024. Commissioner Sussman?
Aye.
Commissioner Barbay?
Aye.
Commissioner Richard?
Aye.
I vote aye.
Item number 12 concerns Empower revisions from Washington Gas Light Company.
Good morning, Chair, Commissioners. Michael Jang on behalf of staff. Item 12 is a filing by WGL to revise its Empower Maryland surcharge for both residential and commercial customers to comply with Commission Order number 91175, which you heard from my previous colleagues. So staff did have some modifications to calculations provided by WGL. Specifically, staff recalculated the gas surcharge for both residential and commercial customers to specifically reflect the months of July through December, as collections for the months of January through June have already occurred. So staff's proposed surcharge for residential customers is 0.0404 per therm, dollars per therm, which is lower than the previous rate of $0.0431 per therm. Staff proposed surcharge for commercial customers is 0.0081 per therm, which is lower than the previous rate of $0.0087 per therm. Staff recommends that the Commission accept staff's modifications to the company's Empower surcharge rates for residential and commercial customers, and direct the company to file clean copies of its tariff reflecting these changes effective with billings on or after July 1st, 2024. Thank you, and I'm available for any questions.
Any questions for staff? Well, actually, let me take, before I turn to...
Good morning again. Nicole Zeichner on behalf of OPC. We support staff's recommendation regarding the calculation of the surcharge using the period from July to December. We also would just ask, which it sounds like staff is recommending as well, that WGL file its proposed tariff language, and if acceptable to the Commission, it then be approved. We did flag that same issue with WGL, but I understand that the Commission would like the average cost of outstanding debt update to occur later. And those were our only recommendations, and I'm available for any questions. Thank you.
Any questions? All right.
Spencer Nichols on behalf of Washington Gas. Mr. Chair, we thank staff for their review. We have been in touch with staff, and we agree with their revisions. The one thing I would just emphasize is to, in the Commission's letter order, if you could direct, as staff has directed, for the changes to be implemented on or after July 1st. It's too late for us to impose the surcharge beginning in July. With respect to OPC's request, the Commission is always in charge of approving tariff language revisions, and the company will be filing, per your order, presumably revised, both clean and revised copies of the tariff that the Commission can review.
Any questions for WGL? All right, so regarding item 12, I move we accept the tariff revisions for filing as modified by staff in its comments dated July 24, 2024, and direct the company to file clean copies of the tariff revisions effective with billings on or after July 1, 2024. Commissioner Sussman?
Aye.
Commissioner Barbay?
Aye.
Commissioner Richard.
Aye.
I vote aye.
Item number 14 consists of empower revisions from Baltimore Gas and Electric Company.
Good morning again, Chair Commissioners. Michael Jang on behalf of staff. Item 14 is a filing by BGE to revise its electricity and natural gas and Power Maryland surcharge to comply with Commission Order number 91175. Staff had one modification to the calculations provided by BGE regarding its demand response service charge, which only affects the residential customer class. Specifically, staff applied the return associated with the average cost of outstanding debt to the unamortized balances for the switches, thermostats, and IT infrastructure categories, in addition to the regulatory assets category that BGE updated in their own calculations. With staff's modifications, BGE's electricity and power surcharge for residential customers is $0.00899 per kilowatt hour, which is lower than the previous rate of $0.00925 per kilowatt hour. Staff determined that BGE calculated the rest of its power surcharges correctly, which are summarized in Table 1 and 2 of staff's comments. Staff recommends that the Commission accept for filing the company's proposed revisions to Rider 2, Electricity Efficiency Charge, and Rider 1, Gas Efficiency Charge effective July 1, 2024. Staff recommends that the Commission accept staff's modifications to the company's Rider 15, Demand Response Service Charge, and direct the company to file clean copies of its tariffs reflecting these changes effective July 1st, 2024. Thank you, and I am available for any questions.
Any questions for staff? All right.
Yes, OPC supports staff modifications to the Rider 15 demand response charge, and that was our only concern aside from the tariff language. Thank you.
Good morning again, Commissioners. Beverly Sakra on behalf of BGE. Your Honors, the changes that staff is proposing to make are to
Actually,
ask...
can you-
Oh,
Yeah.
sorry. Are different than the other costs in the calculations. This is, where we left the weighted average cost of capital are on actual assets, not on the regulatory asset. There are still within the demand response a certain number of assets, no different than lines, poles, whatever, that are used in the demand response program. Switches, the IT, infrastructure to make sure that when someone presses a button, those switches actually work. They're treated differently in the sense of the lives over which they're recovered. They're recovered over, I believe, 10 and 15 years instead of, well, it used to be 5, and now I believe it's 7 and probably changing again. So these are different than the other regulatory asset costs. These are actually physical assets that are no different than any other asset on our system. And that's why we use the weighted average cost of capital on those still.
Okay, any questions for BG&E? Staff have a response?
I'll defer to Dan Hurley. Thank you.
Good morning, Mr. Chair and Commissioners. Dan Hurley on behalf of staff. So I think our view on that is that the law and the order was referring to Empower Maryland costs, and those switches, stats, and IT infrastructure is a part of the Empower Maryland surcharge, and thus we're subject to the average long-term debt rate.
All right, so I'm going to move that we accept the company's, except for filing, the company's proposed revisions to Rider 2 electric efficiency charge and Rider 1 gas efficiency charge with an effective date of July 1, 2024, that we accept the revisions to Rider 15 demand response service charge as modified by staff in its comments dated July 24, 2024, and direct the company to file clean copies of its tariff revisions with an effective date of July 1, 2024. Commissioner Sussman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Item 15 consists of revisions to the Empower Maryland surcharge from the Potomac Edison Company.
Good morning, Chair and Commissioners. Charles Herbert on behalf of staff. Item 15 is the Potomac Edison Company's proposed update to its Empower Maryland surcharge in compliance with the Commission's directive in order number 91175 for the surcharge rates to reflect the utility's average cost of outstanding debt. As noted in staff's written comments, staff recommends that the Commission except for filing the company's proposed revisions to its tariff effective July 1st, 2024. PE made in its filing 2 additional requests to the Commission. First, PE is requesting that the Commission grant the company a waiver of the 30-day rate change notice required under Maryland Code Public Utilities Article, Section 4-203A1. Staff believes that PE's request for a waiver is reasonable given the short timeline for PE to compute its new rates relative to PE's timelines for routine tariff revisions in the past. Therefore, staff recommends that the Commission grant the company a waiver of the 30-day notice required by PUA Section 4-203A1. Second, PE is requesting that the Commission set a hearing where the company would have the opportunity to provide evidence and arguments regarding the enforceability of and material impact of certain cost recovery provisions of HB 864. Staff opposes PE's request for a hearing since the footnote of a tariff compliance filing is not the appropriate method to request that the Commission set a hearing or initiate a proceeding regarding HB 864. Further, PE has not provided a sufficient basis for a hearing, as even if the Commission had the authority to consider the constitutionality or legal authority of a statute it administers, a state statutory scheme of utility regulation does not take property within the meaning of the Fifth Amendment of the U.S. Constitution simply because the scheme does not provide recovery of a certain cost, provided the approved utility rates otherwise provide sufficient compensation. Accordingly, staff recommends that the Commission deny PE's request for a hearing. Thank you, and we are available for questions.
Any questions for staff? All right. OPC?
Good morning. We did not file comments specifically regarding PE, but I did want to flag the fact that PE has provided us with the modeling that we requested earlier in the year regarding their amortization methodology, but we did not address that here because it was our understanding that that would be changed, if at all, in the 2025 tariff. So I did just want to flag that. Thank you.
Potomac Edison.
Good morning, Chair and Commissioners. Jessica Reba on behalf of Potomac Edison. So it sounds like staff and OPC are in agreement on the rates that were filed. So the only issue to address is our request for a hearing on the legality of House Bill 864. You know, staff doesn't think this was the time or place to raise it, but we thought respectfully, since we were here to discuss the rates that are coming out of it, this was the appropriate time to make that request for a hearing. I don't think it's any secret that the company is just trying to preserve to the full extent possible our ability to raise a judicial review challenge of the statute should we choose to do that in the future. I don't think that a separate filing is needed to state the reasons why we think that that review is warranted, the hearing is warranted. I would be happy to provide a highlight of that, none of which is going to come as a surprise to you, if you would like. And to be fully transparent, regardless of how you come out on the hearing, we would have what we needed to move forward. We just need a ruling one way or the other.
So our view is that we are charged with implementing the provisions of the legislation that was passed in the last session, and that we do not have the ability to rule on the legality or constitutionality of those provisions. You're perfectly welcome to take it up with folks who can make that decision, but that's not in this building. So we're actually going to deny the request for a hearing, and and I'll note that we read the footnotes that were in everybody's filings regarding the questions that you have about the legislation that was passed, but again, we're not in a position to grant that relief because that's not our role in this process. So with that, I move we accept the tariff provisions for filing with an effective date of July 1, 2024, grant the company's request for a waiver of the 30-day notice period required under Public Utilities Article 4-203A1, and deny the company's request for a hearing regarding issues related to House Bill 864. Commissioner Sussman?
Aye.
Commissioner Barve?
Aye.
Commissioner Richard?
Aye.
I vote aye. And with that, we're adjourned. Now, we are going to be taking up, finishing up the future of natural gas proceedings, but why don't we take like 10-minute break, 15-minute break? So
11:15.